The SABC reserves the right to intercept, monitor, read, save, block and or act upon any communication and any files stored on any equipment of the SABC. Is the SABC being paranoid, and could this undermine the trust of sources giving information to journalists? And what sort of protection is afforded by the Protection of Personal Information, or POPI Act, which came into effect earlier this year? To discuss, we're joined by Kevin Smith, who's a commercial law expert from Gani Mayet Attorneys. Thank you, Mr. Smith. Is the SABC doing anything unusual here, or is the wording just very explicit about what a lot of companies, I think, are actually doing?
Well, first of all, thank you for having me on your show. It's a pleasure to be with you this evening. In relation to the SABC itself, a lot of companies have taken a similar stance in relation to not only the collection and gathering of information, but also to the storage and dissemination thereof. Now, how it relates to the POPI Act, we have to take it on a case-by-case basis. So we have to always remember that the POPI Act was promulgated to regulate, in as close harmony as possible with international standards, the processing of personal information by public and private bodies in a manner that gives effect to the right to privacy, as per Section 14 of our Constitution, subject to justifiable limitations, which are aimed at protecting other rights and important interests. So to the extent that their actions are not in alignment with this, that leaves the question as to whether they are doing things legally, or whether there is a specific breach in relation to their conduct.
Yeah. Well, can you comment on that? One of the unions, Bamawu, says this infringes on people's constitutional rights and it's a cybercrime act. How far are companies allowed to go in terms of interception and monitoring?
Well, the interception, so to speak, and the monitoring of information, these need to be properly identified through POPI and other legislation. When it relates to POPI, POPI relates to personal and special information of individuals. And that personal information essentially is information which is about a living and identifiable person or juristic entity, which the Act refers to as a data subject, and affects that person's privacy, whether in their personal, family, business, or professional capacity, in the sense that the information has the person or the juristic entity as its focus, or is otherwise biographical in nature and identifies that person or juristic entity. Now, there's a key to note here that in the context of employment, the information collected has to be about that specific individual. Where it is not about the specific individual and relates to a third party, that third party has to either be notified and the information has to be confirmed with that third party in order for POPI to have been satisfied. So to the extent that either a third party or the individual who is not the employee of SABC, their information is collected, that person has to be notified. That person has to have their input as to whether they want the information disseminated, collected and stored, and consent needs to be received. A key part of POPI
Let me stop you, Mr. Smith, because what you're saying is very interesting, and we're going to bring up the portion of the SABC contract that has led to these spying claims. So what you're saying, for example, the SABC says that it can monitor telephone calls, but you're saying that can be legally challenged if there's somebody, and especially if it's a journalistic source on the other side of the telephone call, who doesn't want their phone call to be monitored.
Right. Now, with the discussion we've just had, there is actually an exclusion for journalistic purposes contained within the POPI Act. So Section 7 of the POPI Act actually has that exclusion, which is the exclusion for journalistic, literary, and artistic purposes. And essentially it reads that the Act doesn't apply to the processing of personal information solely for the purpose of journalistic, literary, or artistic expression, to the extent that such an exclusion is necessary to reconcile as a matter of public interest the right to privacy with the right to freedom of expression. Not only that, but subsection 2 goes further on to say that where a responsible party who processes personal information for exclusively journalistic purposes is, by virtue of office, employment, or profession, subject to a code of ethics that provide adequate safeguards for the protection of personal information, such code of ethics will apply to the processing concerned to the exclusion of the POPI Act, and any alleged interference with the protection of the personal information of a data subject that may arise as a result of such processing must be adjudicated as provided for in terms of that code. So to the extent that this applies in our instance, the SABC or its journalists will be covered by Section 7, subsection 1 and 2, as those are journalistic exclusions, which are there for their protection, to the extent that the Code of Ethics by journalists safeguards the information of personal information of any individual, third party or juristic entity.
So this is very interesting. So you're saying journalists have special privileges or cover in terms of protecting their information. Could that help journalists within the SABC take on legally their own employer, the SABC?
Well, that would depend. It would depend on two things. Firstly, as noted before, consent is a big part of not only POPI, but in a collection of personal information in general. Secondly, given that the exclusion already exists and is safeguarded by the Code of Ethics, which journalists are subject to, that essentially does not essentially give them a challenge to their employer, but the challenge could lie in the purpose of the collection of that information. One of the protections of the POPI Act is that the purpose of the collection of the information has to be specified, and you have to have full notice and information given to you as per the purpose of the information being collected, the extent of information collected to serve that purpose, and if that purpose has been served, then the destruction of your information thereafter. So it's not just about the collecting and the interception of information, but it's also about what purpose it will serve thereafter.
Yeah. Well, let's bring in what the SABC has said. I mean, there was a controversy earlier when board members resolved to use the State Security Agency if necessary, because there were leaks from the SABC. Board minutes were being leaked. Some would say that the SABC board minutes are actually in the public interest. The SABC would say it has a right to protect confidential information and its own intellectual property. I mean, you've got people here knowing what sort of shows are planned in a competitive market. So how do you balance those things? Do you think this could make for an interesting legal challenge, because there are mitigating factors on both sides?
Well, I definitely do think that it could make an interesting legal challenge. For something especially along these lines, it needs further judicial adjudication. So it may be necessary for this to go to court for these types of intricacies to be ironed out. With any other legislation, a lot of the provisions contained therein are always subject to the challenges that will happen thereafter. And this is no exception. One thing that is very important to note, which is another exclusion to the POPI Act, is that Section 6 actually states that information by or on behalf of a public body which involves inter alia national security, defense or public safety, and identification for the purposes of identifying individuals involved in money laundering and terrorism also has an exclusion. So in this instance, it would be essential to see how closely tied the SABC and national state security or state defense are linked in the purpose of collecting and disseminating this information, because then that exclusion may apply. Yeah.
Okay, this is all very interesting. If we go back to the beginning, a lot of companies are asking for people's consent. I mean, people have to sign these contracts and say, yes, you can monitor my emails, you can monitor anything I do on company equipment. What is your advice to people then? And I guess be careful, because this information, despite the POPI Act, can still be used against you for a long time. Am I correct?
Yes, correct. Depending also on what type of information has been collected, once the purpose has been served, that information has to be destroyed. So essentially speaking, when the purpose of the collecting of that information has now lapsed, then the company or the entity that has collected and has access to that information should no longer have access to it. So there isn't a specific time limit on how long information should be kept. That is tied directly to the purpose itself. Another thing that companies, not only the employees, but the companies themselves need to realize is that they need to be in contact with the information regulator who can assist them in creating policies and regulations that are industry specific, because certain industries and the use of their information within those industries differ quite substantially. So to the extent that, for instance, in this instance with the SABC, with journalism is concerned, the information regulator has to specify how in these instances they should collect, store, archive, and disseminate information.
Yeah. Well, can I end there, Mr. Smith? Could there be an argument here that the SABC should have one contract for people who work in other departments, and maybe one contract for journalists who may have to deal with sources, and the sources have to trust them, and that is a relationship that is sometimes even bigger than the employer, because the journalist will keep that relationship?
At this instance, I wouldn't necessarily say that the journalists are the ones that are in danger by virtue of these new clauses being brought into their employment contracts, given the exclusions given to us by Section 7. However, the employer should actually extend the clauses that they have put in. The clauses that they currently have sort of a blanket application, which is usually troublesome to implement and troublesome to enforce. So I wouldn't say that they should give different contracts to different people in different departments, but it should be extended so that people within those departments are actually guided on how information will be collected, the purpose for it, and what will be used, what the information will be used for going further. So I wouldn't say it's essential for them to have different contracts. I just think that the clauses themselves should be extended further so that the protections apply where they should in the different departments.
Okay, so you're saying give people information on how and what, not only how their information will be collected, but why, what information and for what purpose. This was fascinating. Thank you. Kevin Smith, commercial law expert at Gani Mayet Attorneys.